Greetings and felicitations again, my fellow perceptive purple people. I wanted to take a few moments to talk with you about the various controversies surrounding the judge in the espionage case in Florida involving Trump, and a law that I propose should be enacted for the future to avoid such issues. First, some background for you. As I'm sure you're aware, former President Trump has many civil and criminal cases either in litigation or pending said litigation soon. These cases have been distributed pursuant their normal district court's case routing system, with, I presume, no favor being involved in these assignations. However, this has led to at least one case where the adjudicating judge was personally appointed by said former president, now defendant, in her court. It doesn't take a law and ethics professor to see how this could easily be construed as a favorable, biased court for the defendant. Now, in reasonable defense of the circuit involved regarding said obviously flawed case assignation, I would point out the word that is being used painfully often these days because it, unfortunately and once again, is accurate in its description. This entire situation is, well, unprecedented. I mean, really and honestly never happened before. This is a unique situation, so mistakes that are obvious in retrospect are, sadly, gonna happen. This is one of those mistakes that is in need of correction, both now as well as moving forward. So the question that now comes to mind is, should a judge, any judge, be permitted to adjudicate a case where one of the parties involved actually appointed them into that position in the first place? As a side note, now, I'm not even going to say that any given judge would, ipso facto, be unable to be impartial in a given case of such a nature. In fact, I would like to make clear that there have been many judges in various levels of the federal judiciary who have shown, beyond a reasonable doubt, that their loyalty lies to the law and U.S. Constitution and not to anybody who appointed them. So please don't think I'm going to go into full accusation mode on this subject. But I believe that even these fine jurists would have no reasonable choice but to admit the logic of our position here, that the obvious conflict of interest, even if only potential, merits such a prohibition. This leads me to the place I hate to go, making yet another law to try to corral the stupid back into logical and intelligent society. But here we are. I propose the immediate federal passage of a law making it illegal for any judge, justice, etc., up to and including justices of the U.S. Supreme Court, to knowingly attempt to litigate any case where the plaintiff or the defendant personally appointed said judge, etc., to that position of adjudication. That's it. There's really not a lot of complication in this one, folks, as it's pretty obvious logical sense. In fact, in spite of this situation being unprecedented, I am rather surprised that this wasn't at least put into place upon the discovery of the potential of charges against a former president. I mean, even if Congress was hamstrung with their harmful political bullshit games, I would have expected at least the presiding judges in each district to have enacted such common sense restrictions. So, what are your thoughts about this? Do you find our position reasonable, or do you have more logical and/or rational ideas on the subject? Do be prepared for vigorous yet polite debate, but let's hear it. As always, I'll see you in the comment section below. Till our next chat, remember to keep your balance and stay purple, people. We'll see you again real soon, and let's get America together again.